Hi, everybody. Thanks for taking the time to join us tonight. We are going to get started right on time today and right on time as well. Just a reminder for everybody that your mics will be muted for the duration of the webinar tonight, and to put any of your questions that you may have, and please do put them into the chat box so we can address them at the end. So before we get started, I'd like to respectfully acknowledge that Interior Savings is situated on the traditional, ancestral, unceded territory of the Salix Okanagan Nation. We would also like to acknowledge that you are joining us today from many places near and far, and acknowledge the traditional owners and caretakers of those lands. My name is Shayden Stewart. I'm an estate planning and life insurance advisor at Interior Savings Credit Union. And I'd like to thank you again for taking the time to join us tonight. Welcome to the premier event of the 9th annual Okanagan Embrace Aging Month. And today we are running this is hosted by the Institute for Healthy Living and Chronic Disease Prevention at UBC Okanagan, Interior Savings Credit Union, and Interior Health. So a bit of a background, Embrace Aging Month was launched 9 years ago to celebrate and raise awareness for the positive aging. And we have once again organized a number of educational opportunities and events during the month of March. So there are more to come, and we recommend that you do sign up if you have the time. These sessions are designed for everybody, young and old alike, and focus on a variety of topics related to the healthy aging and ways to improve your quality of life among seniors and their family caregivers. Our goal is to inspire everyone to embrace positive aging. You may notice that this webinar is recorded and that there is closed captioning. The closed captioning box can be moved around your screen by clicking and dragging it to where you would like. To turn it off, just select the live transcript button on the menu bar. Again, questions. We hope to have lots of great questions from you attendees tonight. Please put those into the chat box as we will be muting all voice lines. Today, the event is brought to you by Interior Savings Credit Union, and it's on the real life estate planning for real people. We've got a couple of great panel experts joining us tonight, and thank you very much for your time and participation. We have Leah Card and Tyson McNeil-Hay, both partner lawyers at Fulton and Company. Leah's her keen insight and reputation for excellence in estate planning and estate administration results from her broad business and property law background and having over 15 years experience in wills and estate law. Tyson McNeil-Hay, also a partner, his law practice focuses on estate, commercial, and local government litigation. As a persuasive, successful advocate, he has appeared at all levels of court in BC. So thanks again for joining us tonight, folks, and we look forward to your presentation. At this point, I think that's most of the housekeeping that we need to get through tonight. I do believe that we will have a midway pause for a bio break for those who need it. And without any further ado, Leah, you can take it away. Thank you kindly.
Wonderful. Thank you, Shayden. Okay, so we will dive right into estate planning for real people. And just a quick note about introduction to our firm. So Fulton and Company, we're located in Kamloops, and we have an office in Vancouver as well. And we were established in 1885. So we've been around this neck of the province for a good long time. We believe, tracing our history back, that we were British Columbia's first law firm, and we can directly trace our ancestry that way. So it's a pretty neat legacy to be a part of. And estate planning is one of our areas of expertise, and that's what we're going to talk to you about today. So through the presentation tonight, you will notice that we keep coming back to certain themes. And these particular themes, there are 4 of them, and they're underlying most of what we talk about and what we think about when we're doing planning and estate planning for clients. So those themes are the question of what is the estate and what comprises of the estate. And then probate. How does probate play in here? Will this estate need to be probated, and what does that look like? Are there wills variation risks of somebody challenging the will, and how do we mitigate those risks? And then lastly, planning for a possible loss of capacity, whether that's sudden or over time. So these 4 themes, we'll be coming back to these repeatedly through the presentation tonight. And we're going to talk about a number of tools that we have in our toolbox, and we use these regularly to create custom estate plans for our clients. And that's what we mean when we say the word estate planning. It's taking a step back and looking at what your assets are, what your family circumstances are, and what tools we need to apply to your situation to optimize. So common tools that we'll talk about tonight. Obviously, the will is the cornerstone to most estate plans. And we look at owning assets jointly between 2 or more people. We might look at, for high net worth individuals, especially business owners, we might look at something called a company will, or we might use trusts for people who have particular concerns or are, again, high net worth. Life insurance plays an important role in any estate plan because it can work really effectively to fill gaps. And then we also, of course, use powers of attorney and representation agreements, and we'll talk about those later, but those come in terms of planning for possible incapacity. So let's dive into the first underlying theme. And that's the question of, what is the estate? So it's a fairly simple concept. You can think about it as your estate being only those assets that will pass through your will to your heirs. And those assets are only ones that you own alone, or ones where you have not designated a beneficiary. So if you have an asset like a bank account or a piece of land or a vehicle that you own jointly with somebody else, then that is, if you pass first and that joint owner is still alive, that asset is not going to be part of your estate. It's going to remain with that surviving joint owner and would be theirs upon your passing. Likewise, an asset where you've actually been able to name a beneficiary, and these are few and far between, but for example, your RIF, your RSP, your TFSA, and life insurance. So those are very common. It's very common for folks to name your beneficiary. And then those funds in those accounts will actually pass direct to that beneficiary and not through your will. So no matter what your will says about them or about your general estate, if you've made a beneficiary designation that's effective, then those funds will pass to the designated beneficiary and not through your estate. So why do we care? Well, of course, it's only what's flowing through your estate that your will govern. And then you may have to go to probate, and I'll talk about that in a minute. So probate fees will be charged on the value of the estate. Your estate assets are also going to be subject to payment of monies that you owe at your death. So if you owe money to CRA or your next door neighbor, or you have an outstanding bill or a credit card debt, all of that has to be paid first by the assets of your estate. And then what's left over will pass per the terms of the will to the beneficiaries. And then, of course, all the assets that are in the estate governed by the will are subject to being challenged if that will is challenged. We'll talk about this in more detail later, but there is opportunity in BC for someone to challenge the will, and they can then seek to get access to the assets in the estate. So we need to know what assets are in the estate, what assets are passing outside of the estate for all of these reasons. For the assets that you have governed by your will that are part of the estate, in most cases, if these are significant, so if the value is there, then it's going to be brought into the probate process. So probate will be needed to transfer those assets to your executor first, so that that executor can then govern and control how those assets are handled and dealt with. And then from your executor to your beneficiaries, or perhaps your executor sells them. So probate is required by third parties that control the transfer process of assets. So third parties like the land title office. In order for land, real estate, to be transferred to the executor from the deceased person, the land title office requires the estate to be probated, the will to be probated. You'll also see that from financial institutions. Before they will give the executor control of funds within their institution, they will require the probate. Auto plan is the same for transferring vehicles, and there are many myriads of others. And the question is why? And the answer is because the grant of probate that's issued through the probate process by the court confirms that the executor of the will is the rightful executor, and confirms then that if that third party takes instruction from that person, that executor, and gives up control of the asset to that executor, that third party is not going to be held responsible if that executor does something untoward. Or if it turns out that that wasn't the most recent will and that's not the proper executor, that third party can still rely on the fact that they were acting under on the basis of a grant of probate when they handed control of that asset over to the executor. So they're protected. So it's for the protection of the third parties handling the transfer of the assets. And when do we need to probate? So I've kind of alluded to this. And if we have a spousal situation where most of the assets or all the assets, all the significant assets are held jointly, then typically there's no probate needed. All that has to be done is that death certificate of the deceased spouse would be presented at the bank and at the land title office and at auto plan, and the deceased spouse would be removed from the joint assets and leaving the surviving joint owner there as the sole remaining owner. So it's not falling in the estate of the first to die. So there's no probate. Then when the second spouse passes away, they have assets. All those acquired assets are now in just their name in most situations. And so then we would have a situation where we have to transfer those assets, and the third parties like the land title office and the banks will kick in the probate requirement. So most situations when we're doing estate planning for spouses, we're looking at opportunities to reduce the requirement for probate on the first spouse to die, and then we're looking at what will probate look like when the second spouse passes. Probate fees, so again, this is an example. Probate fees are levied by the provincial government in BC, and our rates here are some of the most expensive in Canada, 1.4%. I think Ontario beats us by a small margin, and some provinces have no probate fees. So it can be significant if the estate is a significant size. So the first example is the situation where there are two spouses, but they hold everything jointly, or they've beneficiary designated everything to each other. When the first one passes away, there's no probate. Nothing's passing through that estate of the deceased who died first. But then if we had a $300,000 estate and the second spouse passed, your 1.4% probate fee adds up to just over $4,000. So that's a rate that just is paid to the provincial government and to government coffers, and they haven't made any suggestions or contemplations about reducing or increasing probate fees. So by all accounts, they're here to stay for the long term. So let's talk then. We know now in some circumstances probate will be required. Let's talk about how we do that. How do we probate an estate? So the executor will take a number of steps. Number one is sending a copy of the will over to the beneficiaries and or everybody who's entitled to it by law. So that's somebody who might be entitled to receive an inheritance from the estate if there has been no will. We'll talk about that in a minute, but it's sort of a next of kin chain down the line. So the beneficiaries get a copy, as do anybody who might inherit if this will is invalid. This also covers anybody who might be able to bring a will's variation claim against the estate. So there's a big catchment pool of who needs to be notified of the passing and who's entitled to the copy of the will. This often comes as a surprise to people, the fact that the entire will is going to be produced. The executor also needs to go through a fairly thorough process of reviewing the deceased person's affairs, getting quite familiar with what was happening in their life, all with a view to determining what the assets now are as of day of death. So the executor needs to compile a very fulsome listing of what the deceased person had when they passed, and values for just pretty well everything other than personal effects. You don't need to delve too far into the detail about personal effects valuations, but land certainly, date of death values on accounts, vehicle value, etc. And at the same time, the executor is compiling a list of debts and obligations. So getting a handle of what the job's going to look like. And then the executor will prepare affidavits, and this process is just to tell the court a bit more about the estate, the deceased, the will, the family, next of kin, and then also the list of assets. And so this list of assets shows the final total at the bottom, and then that's what the court assesses the 1.4% probate fee on. And then they will tell the executor how much is owed in probate fees. And once the fees are paid, and usually the fees are paid by the deceased's accounts at a financial institution, very rarely paid out of anybody else's pocket. The fees would be paid, and then the court will actually issue the grant of probate. And that's a fancy looking document with a fancy stamp on it. And that is the executor's key to then start getting control of and accessing assets so that they can deal with things. I'm going to turn it over to Tyson for a quick word here.
Thanks, Leah. Yeah, the next underlying theme that we have here is about wills variation, and Leah's alluded to this a couple times. Wills variation is sort of a special law we have in BC. The only other one that's directly comparable is in Nova Scotia, that permits both a surviving spouse or a surviving child of a deceased person to contest a will purely on the basis that it's essentially unfair to that person. So the question who can bring a claim, as I said, it's spouses and children. So spouse includes married and also common law spouses, as we call them, which means a 2-year cohabitation at minimum. Children includes dependent or independent adult children, as well as minor children, obviously, and it includes adopted children. It doesn't include stepchildren, doesn't include siblings, parents. It also doesn't include grandchildren, which is important sometimes if there's a situation where a child predeceases a parent, but the child themselves has children. Those grandchildren don't inherit that their parents' wills variation rights against the grandparents. So that's important to keep in mind. Leah's just gonna, there we go, to the next slide. So essentially what is wills variation? It's a lawsuit. It's as we call it, a court action that's filed in court, where the claimant, the plaintiff, person who's seeking the variation of the will, essentially asks the court to rewrite the will in their favor, to award the applicant a larger share or a larger amount, whatever that is. When these things go to trial, the courts have a great deal of factors to consider, but the Supreme Court of Canada tells us that what a court is supposed to consider, the sort of touchstone, is the society's reasonable expectations of what a judicious parent or spouse would do in the circumstances. And the courts talk about these legal and moral duties. So if you, a legal duty can arise, for instance, between spouses because of family law, matrimonial law, property division, and that sort of thing. When it comes to children, there's a lot of talk about moral duties. And the courts have found that these moral duties can sort of be entwined in wills variation, and that where the estate's big enough, the court tries to kind of assess what moral duty the deceased person owed to their various children and spouse. And some things that go into that, does that, if it's a child, do they have a disability? Did the child sort of have a legitimate expectation of receiving an inheritance? Are there other difficulties in the child's life that might sort of weigh in favor of them getting a higher amount? The size of the estate, as I said, it's quite important. Really, these things, there's all sorts of factors that go into what the courts decide in wills variation, and it can make it quite difficult for lawyers like me to advise people about what they can expect if there's a claim, because there's a very wide array of circumstances and of results at the end of the day.
Thank you, Tyson. So getting back to our tools, what we have at our disposal when we're looking to create an estate plan, let's talk about the will. So plenty of key elements involved in making a will. We're going to be appointing executors, nominating beneficiaries, appointing guardians. We might be looking at trust terms to build in more expansive trust arrangements for certain people. And we're going to set out the powers and the authority that we give to the executors. So starting with the question of executor, we're often asked, who can you appoint and who can you choose? So it is entirely possible to appoint a person as a beneficiary who is also, a person as executor who is also a beneficiary under the will. And that's a very common approach for families. Mom and dad make a will, they appoint one or more children as executor, and all of the children are beneficiaries. So a person can wear more than one hat. That's entirely appropriate in certain circumstances. What you typically look for in choosing an executor is somebody who kind of meets these criteria. So somebody who has the interest and is willing to do it, who is a trustworthy individual and will be able to sort of navigate relationships with the beneficiaries if that could be complicated. Someone who has the organizational skills and the administrative skills to be dealing with paperwork. Of course, longevity is always a question, and it's wise to choose somebody who has a decent chance of outliving you. And residency. So we don't want to have an executor who lives in the USA for tax reasons. There are some negative tax consequences to that. But someone in another province in Canada, it's entirely doable. Executors typically find they actually have to be on the ground in the city where the deceased passed away for a week, maybe two, or interspersed between those first couple weeks. And then if there's some real estate that has to be dealt with, there's typically a house that has to be cleared out. Somebody needs to do that. And then by that point, if the executor is ready to leave town, if they've gathered up all the paperwork and they know all there is to know, they can leave town and they may not need to return. So if you have somebody living in Ontario, it's absolutely workable, and of course all of their costs would be covered. I mentioned too that large estates, particularly ones where there is no good candidate for the executor role in that circumstance, another option is a professional trustee. So as lawyers, we're asked frequently if we could be executors for our clients, and typically our policies is that we don't do that, but we do work hand in hand with professional trustees like trust companies. And there are a number of those that operate within BC. So for states of a certain size, it's an option to hire somebody and they don't get paid until you pass away and they actually take on the role. So we'll talk about the big job that an executor has. And the next question is typically, well, if you ask someone to be your executor, they want to know what's in it for me. Your answer might be, well, you're a beneficiary of the will, so there's nothing else in it for you. Just do the job for the benefit of all the beneficiaries, which is fine. Or you might want to actually provide that an executor is allowed to take a fee. If your will is silent, then the law default says that the executor is entitled to be paid. because it's a job that's worth remunerating. So this comes out of the estate. Of course, it comes like, the bills are paid and the taxes are paid and the executor fee is paid. And then whatever else is remaining goes to the beneficiaries. So in terms of how we set or arrive at a fee, the guidelines under the Trustee Act are if the will is silent, then the maximum that executor can claim is 5% of the capital, one time 5%. And they could also charge 5% of all the income that's earned on the assets in the estate. So 5% is the typical cap. Beneficiaries can agree to more. But the caveat there is it has to be reasonable and can measure it with the amount of work that was done. So if it's an extraordinary large estate, but it was simply one account, didn't take much to deal with it, the executor probably hasn't earned themselves a full 5%. So there are a few principles that an executor needs to know when they want to be paid. So they have to be, the fees and the remuneration has to be approved by the beneficiaries. Failing that, if there's no approval and no agreement among beneficiaries about how much the executor can be paid, and sometimes there isn't for various reasons, the executor then needs to take the matter to court. And they need to go ask the judge to review the material and fix a fee. So that does happen with a lot of frequency. But most often, executors come to some agreement with the beneficiaries and a fee is agreed upon. All that to say that if you're acting as an executor and you're anticipating you want to take a fee at the end of the day, you need to keep pretty good records about what you've done to earn that fee. So a log of what you do and all the time you spend acting on behalf of this estate can go very far in justifying your fee. Executor duties.
Thanks, Leah. So in terms of what the executor's duties are, they really fall into two sort of different categories here. The first one is what we call the fiduciary duty. Fiduciary comes from the Latin word fides, which means trust or honesty. And if the fiduciary duty is about enforcing the executor's responsibility to treat the estate with utmost good faith, to be absolutely honest and transparent, make full disclosure, all that sort of thing. And so those duties are very powerful. The fiduciary duty is sometimes called the strongest duty known to law. And the beneficiaries have the right to call executors to account who have breached those duties. And that happens in sort of myriad different ways. Executors who take money from the estate, executors who, use estate money to invest in their spouse's business, or find out about a business opportunity for the estate, but take it for themselves instead of letting the estate take it. All those sorts of things can be breaches of fiduciary duty. Another big potential breach of fiduciary duty is this, part of it is this duty to treat the beneficiaries with an even hand. And quite often you get executors, and I shouldn't say often, it comes across my desk often, but probably doesn't happen that often overall, where the executor is clearly favoring one beneficiary over another in some way. And that's another potential breach of fiduciary duty. Then we have what we call the common law duty, or the regular duty of reasonableness that we all have in our own lives whenever we're doing anything, whether that's driving or walking down the street. The law expects you to act reasonably, and when you're an executor, the law expects you to administer the estate reasonably. So that duty often sort of comes out in, well, did you make sure the insurance for the house was paid? Because if the house burns down and now there's no insurance, you could be liable for part of that loss if that was found to be negligent. And it's also things like how you invest the money of the estate. Have you invested that in a reasonably prudent way, or did you stick it all in a crazy risky investment that no prudent person would ever do? Those kind of things can be breaches of the executor's common law duty, and can lead to liability and negligence for the executor. Or more likely, what we see is when there's those sorts of allegations, the executors will sometimes compromise by taking less of a fee or taking no fee if there's some allegation that they caused the estate loss through negligence. The next one, Leah, I think is mine as well. Yeah, in accounting to beneficiaries, this is the executor's big responsibility sort of at the end of the day, or close to the end of the day when most of the estate has been administered. The executors will produce this accounting, which is a sort of true and complete ledger of what they've done with all the financial assets of the estate. So normally it starts off with, here's what the estate has when I took over, here's what the expenses have been, here's what the income was, and here's what we're left with at the end of the day. Generally, the next part will be the executor saying, well, here's the fee I propose to charge, and then here's what will be left, and here's how I propose to distribute that to the beneficiaries pursuant to the will. Normally what happens is the executor prepares something along those lines. It's sent out to the beneficiaries who are asked to consent to those accounts, take a look at them and then sign a consent release form. If it's not approved by the beneficiaries, which is I think Leah alluded to earlier, then potentially it will have to get approved at court. And sometimes that happens because the beneficiaries are minor children. Minor children can't validly approve these sorts of things. So for that reason, sometimes you have to get accounts to court even if there's no real issue with them. But where there is an issue, it can be quite a lengthy court process. It can be pretty similar to a trial in terms of the executor trying to justify the fee that they're charging or some of the expenses maybe that they paid from the estate or those sorts of things, and the beneficiaries might be in there with lawyers asking questions, and there could be expert opinion evidence. It can get very involved when it comes to passing accounts, so it can be quite a complicated process. I think, Leah, it's back over to you now.
Okay, so going back to the will, and these are the components of the will. We digressed a little bit. We told you about executors, how they're paid, and what their accounting obligations are. So now you have a sense of what it takes to be an executor. So now let's talk about the other components of the will. And a key piece, obviously, is who's going to be the beneficiary or multiple beneficiaries. So we're dealing with personal effects and also with all the other assets that remains after your debts and liabilities have been satisfied. So that's called the residue of the estate. And typically, this involves spouses, children, could involve your stepchildren, may involve your grandchildren, may involve charities, or even extended family and friends. And I put a few notes in the slides there about things to consider if you're thinking about involving grandchildren in your will. And a key one is, what age do they have to be before they can get their hands on the money? And then who manages that money for them until they reach your chosen age? Because a child under 19 is not able to inherit from a will. If they're under 19, there needs to be a trustee appointed to manage that money for them. And that's all set out in your will and detailed there. And then charities often play a role. Most commonly what I see is a flat gift of an X amount of money, say $10,000, to a particular charity, with or without a particular purpose attached to it. That's entirely your prerogative. And we always encourage you to have conversation with the recipient charity while we're preparing the will before it's signed, to get input from them about what language they'd like to see and how they want to see that worded in the gift worded in the will. Charities do often play a role for clients when they're thinking about contingency plans. So the what if question: what if my beneficiaries die before me? Then who would be receiving my estate? And this is frequently where we see a gift of the estate to one or more charity beneficiaries. I mentioned trusts for beneficiaries, and these are pretty critical components of estate planning, and they're extremely common. So you are always going to see a trust in a will if there's a beneficiary who's a minor, or a potential person who might potentially inherit who could be a minor at the time of inheritance. And typically, the trusts are set up so that there is a money manager. So the money is tucked away in the hands of a trustee that you choose. And quite often, discretion is given to that trustee to spend that money up until the point when the trust ends for the care, education, maintenance, and support of that minor child until they reach the age that you've chosen. And maybe that's age 25, and then the remainder of the trust money would be paid over to the beneficiary. Often see this too, where will makers have concerns about the responsibility and the ability to handle money responsibly of their beneficiary. Then they would rather have some parameters put around that inheritance. So we could do a trust for somebody who might be suffering or experiencing substance abuse, for example, or somebody who is potentially somebody who can be easily influenced. And maybe there needs to be a money manager for that person. And we often see it for disabled people who maybe don't have the capabilities of handling their own inheritance, or where that inheritance might interfere with their entitlement for their disability pensions. So a trust can be a good tool there to capture all of those needs. Guardians, of course, are a critical component of a will for parents who have minor children under 19. So there needs to be a guardian appointed, and there should be typically a backup too. So usually the language is something like acknowledging that my spouse or my child's other biological parent would be their guardian if I died. But if the biological parent can't be the guardian, then I appoint so-and-so and so-and-so. So building in redundancies wherever you can is a key piece to a good will. And that goes back to your executor choice, your guardian choice. Build in as many different kind of backup options. So you typically want one executor and at least one more backup executor, just because we don't have a crystal ball. So we need to plan for the worst. And a point here at the end is that if there is no acting valid guardian, the province will take over until there's a guardian who's legally appointed through the courts. Okay, and so we're at our 5-minute break. We are going to mute and turn our cameras off. So everybody feel free to head out for a 5-minute bio break, and we will be back at 7:13. Thank you.
Perfect. Thanks, Leah. Thanks, Tyson. We'll see you folks shortly. For those of you who may have joined a little bit late or came in during the presentation, I just want to welcome you again. Thanks for joining us tonight. We're just in the midst of a break right now, but if you do have any questions, please type them into the chat. We will be addressing them after the presentation. Thank you kindly. We're going to get back to the presentation in about 2 minutes. So whatever you're getting up to, folks, if you want to wrap that back up so we can keep moving along on time. We want to respect everybody's time here. Thank you kindly.
Okay, carrying on. So I left you with a few fun facts about Fulton, and I need to update the last slide because I was talking about one of our former partners, Len Marchand, who is now a judge with the BC Court of Appeal, not Supreme Court. So we will update that slide. All right.
All right, next few slides are for me. So one of the first things we want to talk about is the importance of making a will. And so the title is kind of self-explanatory, the problematic nature of dying without a will. And we put some examples here. Obviously, we often get the people saying, well, why do I need a will? I own everything jointly with my spouse. Of course, that, as Leah said before, that holds true for the first of the two spouses to die, doesn't necessarily hold true for the second one. And unfortunately, the chances of one of you surviving forever is not very good. So you do need to make provision for what happens after the first spouse passes away. The second spouse needs that will. If you don't have a will, it means that there's obviously you can't make provision for anyone other than what is set out in our legislation, which is a sort of a very cookie cutter approach to what happens to someone's will when they die. If you die with a spouse and children, it's divided between the spouse and children. If you don't have a spouse, it goes all to your children. If you don't have a spouse or children, it goes sort of out to different next of kin. But I said it's very cookie cutter, so there's no way to make provision for stepchildren, siblings, charities, friends. You don't get to divide your estate how you want to the people that you want. Another obviously downside if you have not having a will, minor children, as Leah was talking about, having a trust in place for minor children is a part of almost every will that's made now. If you don't have a will, obviously you don't have that kind of trust in place. And it means that if some minor child, whether it's a child of yours or a grandchild or a niece or nephew, becomes entitled to a share under the will, it actually gets paid to the public guardian and trustee, and the public guardian and trustee manages it in trust for that child until they turn 19, and then they get all of it. So really not a great scenario. The public guardian trustee charges fees. They're not exorbitant. But if you had a family member doing it or something like that, you might avoid that scenario. Someone has to step up to be your administrator. That's what we call it when there's no executor appointed. The grant of probate is issued in that case to someone called an administrator rather than an executor. So someone has to step up and do that. There could be a fight over it. Who's the best person to administer it? And that frequently happens in the case of blended families, where you may have a contest between the children who think one of the children should be appointed and the spouse who thinks that he or she should be appointed. So that's another thing, that having a will with a properly appointed executor will save you. If there's minor children, like I said, trust is the trust money is one concern. The other concern is that you won't have appointed a guardian for those minor children, and Leah talked about the downsides of that. More than just a contest about who might become your administrator, if you haven't had an appointed executor, it means that there's no will out there that someone can take to the bank and say, hey, I know I don't have a grant of probate yet, but can you give me some information about the accounts, that sort of thing. Everyone starts from scratch without any authority whatsoever, and that can really hold things up as well compared to a situation where there's an executor with a properly made will. So those are some of the reasons why it's important to have a will. And I sort of alluded to this before. If you die without a will, it's called dying intestate. And if you survive by a spouse and children, it's split between them in this way. There's what we call preferential share for the spouse, which if if your spouse is the parent of the children, then the spouse gets $300,000. If it's a blended family, the spouse would get $150,000, and the rest is split equally between the spouse and the children. So that's what will happen if there is no will. And so, as an example, we have a couple, and I think for the purpose of this example, we named them Bonnie and Henry. It's their first marriage. They're both they have young children. Bonnie owns the house in her name solely, free and clear. It's worth $500,000. They have everything else they have is joint, or they've designated each other as beneficiaries. But the house is in Bonnie's name. Maybe she pre-owned it before the relationship. Now she dies first. She has no will. Well, what happens? Henry's going to receive all the money. He gets her TFSA, her RSP. He gets the cash in the joint accounts. So the only thing that goes into her estate is the house. But now Henry's in a difficult situation because he's only actually entitled to the first $300,000, and the other $200,000 of the house value split between him and the kids. He's got to go try and make a deal with public guardian and trustee to keep ownership of the house. Probably he has to take a mortgage out to get enough money to pay out the kids, and give that money to the public guardian trustee to hold it in trust. So you can see that just even a will that's not very well drafted or is very simple would be much better than this scenario, in the case of Bonnie dying without a will. And the next one, Leah, please. Along the same lines, here's a few more sort of examples of what can happen when you die without a will. The first example, you have a blended family, and all the assets are in the husband's name, quite wealthy. He dies without a will. Well, now him and his wife have been married for 50 years. They don't have children together. He's got children from a previous relationship who were estranged, and haven't seen him in 20 years. So now he dies first. He doesn't have a will, and the biological daughters, children from the previous relationship, they have to be given notice. They come out of the woodwork, and they are entitled to a significant chunk of money. I mean, on a $4 million estate, each of them would get something like $666,000. Something that the deceased in this case probably would not have wanted or intended had he made a will. The next example there is a single parent with one young child. This is a case that Leah and I worked on several years ago, where the facts are taken from that case. The young child, there's no will. So after the mother passes away, it's actually the grandmother has to apply for guardianship over the child. So she's got to make, in the midst of her grieving and figuring out what to do practically, she's got to go make a find a lawyer and make a court application to get guardianship. She's got to take charge of the estate, so she's got to be appointed administrator. she's got to make a separate court application to get appointed as trustee of the estate money in place of the public guardian. So the whole bunch of steps she would have to go through that if her daughter had only had a will would not have been necessary. The next one, Leah, please. So this is one of the other themes Leah talked about at the outset is joint assets. Essentially this incorporates the idea of gifting prior to death. And quite often the way that people do that, they do this sort of cheap estate planning tool where they just put their children or whoever they want, their beneficiaries' names onto their assets, whether it's the house, the bank account, the investment account, and so on. So there, obviously the reasons people do this, it reduces or even eliminates probate fees if it's done properly. Assets that pass by way of this joint ownership aren't exposed to wills variation claims. So if that's your big concern, you've got some black sheep child that's been estranged for 20 years and you don't want them getting 1 red cent of your money, this is another reason why people sometimes go down this path. You get to give the gift immediately, so sometimes that's beneficial. You want the child to have access to some of that money before your death. You can also postpone the gift or part of it until you die if it's sort of done correctly. And it's a little bit tricky to do, but it can be done. Some people worry about the public aspect of the probate application, which involves essentially your executor swearing a big affidavit about all your assets. Some people don't like that idea, and this is a way that it could be kept more private, more confidential. On the other hand, unfortunately, there's a lot of downsides to joint asset scenarios, and we've listed some of them here. You add your child to title to your property. Now, all the child's creditors, if the child runs into difficulty with their finances, say they're in business, their creditors are the first thing the creditor does is a land title search, and they're gonna see that property with the child's name on it, and they're gonna go slap a judgment on it. And now you're gonna be stuck explaining to the creditor how your child actually doesn't own the property, you just put them on there for convenience sake. It doesn't always work, and sometimes it's gonna cause a bunch of hassle or legal expense to make that work. You lose control or autonomy over the asset. In this particular, it happens with bank accounts and with land. Obviously, if you add someone to a bank account, they could drain it the next day, so you're vulnerable to that. And some of the saddest cases that I've dealt with are situations where the elderly parent has added a child to joint to title to their property. Then there's a falling out, and now the elderly parent needs to move. They need to move into care or to a smaller home. And the child basically says, well, yeah, sure, pay me my half, and I'll sign off. That's obviously an enormous loss of control and autonomy for the elderly person. Joint ownership transfer can't necessarily be undone except if the joint owner consents. So again, if you have a falling out, that can create big difficulties. It can create confusion about what you intended to happen. And that there's an inherent sort of vagueness when it comes to joint ownership that gives rise to lots of litigation. So I deal with a lot of that stuff all the time, and it obviously can tear families apart and cost everyone tons of money and hassle and everything else. And there can even be tax consequences if it's seen that the asset was disposed of. It can trigger taxes. So joint asset, it can be done right in the right circumstances, but it's definitely not the sort of blunt force tool that a lot of people think it is when it comes to estate planning. I think we're back over to Leah now to talk about trusts.
Thanks, Tyson. Joint tenancy is a tool listed in the list of tools that estate planners use, but we approach it really, really cautiously. And when we are going to utilize that for our clients, we do a lot of work in the background too. So we have additional documents signed that do really carefully set out what the intention is. Is the child being added to the account just for convenience, or does the account and the money in the account actually belong to the child now, or is the child just a custodian of it for the parent and is not supposed to touch it until the parent dies? And then when parent dies, is the child keeping that money for themselves, or is the parent sharing it, or is the child sharing it with the other siblings or other beneficiaries of the estate? So there are so many different nuances that the law in Canada and British Columbia has developed so specifically about joint ownership, it's not cut and dry. It's fraught with pitfalls and difficulties, and it gives rise to, I mean, Tyson would know more than I, but it gives rise to probably a rough guess 60% of litigation in the estate context in BC. So it needs to be approached with caution and not sort of as a quick fix. So that's my cautionary tale. Okay, so talking really quickly, I just wanted to highlight a tool here for particular types of trusts known as alter ego or joint partner. And these are trusts that we use particularly for high net worth clients or clients where there is a significant risk that they're exposed to a wills variation claim and they have enough of an asset base to warrant the extra belt and suspenders of a trust. And this would just be a trust that they would establish for themselves during their lifetime and that they control. And then they would move their personal assets into this trust. And the trust would actually go so far as to say, when I die, do X, Y, and Z, and give the assets to the remaining beneficiaries. So it kind of looks and functions like a will. But by porting your assets from your estate over into this trust, you've just diminished your estate, which is great for mitigating wills variation claims because you've shrunk the pool of assets that are available to be clawed back if someone challenges your will. A challenge can still be brought, but there's not much there for them to get their hands on because all the valuable assets are in the trust. Of course, there's a side benefit of the probate fee avoidance too, so some savings for the estate there. Blended families.
So blended families are sort of a topic unto themselves, and you could, Leah and I could probably have a big long presentation just on that. This situation, that scenario of the blended family is the main driver of estate litigation and estate disputes for sure in BC, and the mistrust that arises between children and then the surviving spouse. And so it's really important when you're thinking about planning in a blended family scenario to think about all the different options and make sure that that the sort of right path is charted, because all those situations are different. You know, a long time ago, lawyers were very used to writing us one kind of will for spouses, right? Mirror wills, exactly the same. With a blended family, that's almost never the right thing to do because of the way the myriad different ways that people divide up their assets in blended families, how they own them, and what they want to happen to them when they pass away. So wills variation risks are even more heightened in blended family than other situations, because if you do have a scenario where the surviving spouse is going to get most of the estate, well, the children of the deceased person, the first one to die, they don't have any wills variation rights against their stepmother or stepfather's estate. They either have to accept what they've been given, or they have to bring a wills variation claim against their parents' estate when they die. So that you know, that alone, without proper planning, can really rip apart a family that otherwise might have been fine. Everyone might have got along, but that forces a terrible decision for the kids in terms of bringing a wills variation action or not. Other options, some options to potentially avoid that. Life insurance can be used to make sure there's some immediate cash to gift to children while the rest of the estate assets remain with the spouse. That's one way it can be done. There's trusts that can be put in place, testamentary trusts, so trusts that, unlike the ones Leah was just talking about, that take effect upon death, that come out of the will, for the children of the executor to hold assets in trust for the spouse. That's a way the spouse, for instance, could stay in the family home for the rest of his or her life, or have some access to investment income, but not the capital of the investment, those sorts of things. And then everything passes to the children once the surviving spouse passes away. There's the alter ego and joint partner trust that Leah was just talking about, is another good option in some scenarios. But one thing you can't count on is, of course, the surviving spouse is free to change his or her will afterwards. So, you know, two spouses in a blended family might go and make those mirror wills with each other, sort of relying on each other, maybe implicitly, that they won't change it. Well, things change and your surviving spouse might outlive you by 10 or 20 or years or longer. They might even have a new relationship. So all that can change, and you can't rely on their will staying exactly the same. I think Leah's going to talk about life insurance now.
Quick note about life insurance. I mentioned before, it's a really flexible tool that can fill a lot of gaps. And so I've listed some of them here. So life insurance passes directly to the beneficiary of the policy. It's not, unless you have no beneficiary, in which case the money would flow into your estate. If the money's coming into your estate, it's subject to probate fees and payment of your debts. But if it's directly designated to a beneficiary, it's not subject to your creditor claims, and it's just going to be inherited and received by the beneficiary tax-free. And it's nice, clear, clean money. So sometimes we do use that, as Tyson mentioned, in a blended family context where we might want to appoint children, for example, of the policy, whereas everything else might pass to the surviving spouse. If the funds are left with no beneficiary appointed, which sometimes we do by design, because we want to funnel some money into the estate so that it's available to pay income taxes, for example, can be a big debt or other debts. We've talked about it can be used as a sort of a side tool to mitigate the effects of a potential claim to the will. We can also use it for assisting in equalizing gifts given to different people. So maybe you have a situation where the parent really wants the child to get the cottage at the lake, and we need to create an equivalent asset for the other child. Maybe it's a life insurance policy. So state equalization is an option, and then also charitable donations can be really easily achieved by donating your life insurance policy. Okay, and power of attorney. Okay, so that basically wraps up the conversation about wills, right? About what are we going to do when you die? So now let's turn to what happens when you're living, but you've lost capacity. Your capacity is diminishing, or maybe is past the point, and you no longer have the legal capability to undertake tasks for yourself. In that situation of incapacity, we need to do a couple of things. So we need to look after the legal side of things, financial and legal, and we need to look after the medical care, the personal care decisions. So starting with the financial and legal side, that's when the power of attorney comes in. And here it's a very powerful document. It's very important. We should all have a power of attorney, but it's very all-encompassing, because you're appointing somebody who then can now have control of your affairs. So they can pay your bills, they can deal with your investments, they may sell your house or your vehicle, they may purchase a new house for you to live in, they may deal with your pension providers, they would file your tax returns. So it gives them almost carte blanche access to and control over your assets. Always subject to the overriding obligations of somebody acting like an attorney, which is very similar to what Tyson talked about for the executor. So the person acting under your power of attorney has a fiduciary duty to look after your interests and only your interests to the best of their ability, and they cannot use their power to benefit themselves. So there are some limitations on what they can do. But it's really important, because if there's no power of attorney, and I've lost capacity and I've never made a power of attorney, my spouse does not automatically by law have the right to do anything on my behalf. That is not a right that's afforded just because we're in a spousal relationship. My spouse, it's true, may be able to access the money in our joint account. I mean, he would. There's no issue there. He can access the money in what we hold jointly, but he couldn't sell our house because I'm an owner, and me and only me and my power of attorney can sign a transfer document to sell the house. He could not sell my car. He would have no standing or authority to deal with my pension providers. He could not issue trading instructions on my investment accounts. So you're very hamstrung if there's no power of attorney and someone has lost capacity. In that situation, the only option is I didn't put a slide up here, but I'll just let you know, for people who have very simple affairs and very few assets, like one bank account and maybe they're receiving provincial disability assistance from the government. If they have enough capacity to make something called a Section 7 representation agreement, maybe you can get by with that. So that's an option, something to talk to a lawyer about if you're in a situation where you need to help somebody who has diminished capacity. But for anybody who has any real more significant amount of assets, the only option is going to be going to court for what's called a committeeship order. And committeeship is essentially an adult guardianship order. It's a declaration by the court that I'm incompetent and that this is a permanent or unlikely to resolve situation. And it's an appointment of somebody to be my committee. And then that person has the ability to look after my affairs, my estate. That's a court application. It's expensive. It takes a long time to get there, and it requires evidence and support from physicians who can attest to the incompetency of the patient. So it's a last resort. That's why we, as lawyers, are heavily recommend power of attorney and getting it done before it's too late, because there can come a point when somebody doesn't meet the test, the capacity test that they need to meet in order to make a power of attorney. The capacity test for a power of attorney is generally, do you have an understanding of what your assets are? Do you have an understanding of who you owe obligations to, who your dependents are? Do you understand the purpose of a power of attorney? So there's a fairly high level of comprehension required. It's not to say somebody who's suffering or experiencing some dementia can't make a power of attorney. That's not true. They may still have capacity to do that, but it needs to be done very quickly and before things deteriorate. Further along the spectrum of incapacity planning is the notion of a living will, and this can kind of be thought of as a do not resuscitate style direction. And it typically forms basically a one-page document where you simply express that if you're in and nearing the end of your life or at the end of your life, that you don't want life support to preserve your life if death is imminent, but that you would accept palliative and pain control measures. And this is binding on care providers, hospitals, your next of kin, etc. So it's an expression of a wish. That's all it is. I note it's not a substitute for a maid. In Canada, as things stand right now, maid, of course, is medical assistance in dying. And in Canada, the only person who can authorize the end of your life is yourself. You can't have somebody else do that for you. So if you have lost the capacity to make your decision to end your life, nobody can make that decision for you under MAID. So at the other end of the spectrum in the life, in the incapacity planning realm, is a representation agreement, but this is kind of like a power of attorney, but it covers medical care decisions. So it covers decisions about your body and the care you receive. So you choose a decision maker and you probably choose another alternate, and it's going to be their role to see you through and to take care of all decisions that are made from now until the time you pass away. So it runs the gamut between very mundane, everyday things like do you go to the chiropractor and do you get dental work, to end of life care and withdrawal of care in the right circumstances. It also is, this document vests this person essentially as your medical advocate. So they are your voice and they are allowed to access your records and your information, to talk to your doctors on your behalf and make decisions for you. And if there's no representation agreement, so if you've never taken the step to make a representation agreement, there is sort of a it doesn't work very well. No default at law, referred to as a temporary substitute decision maker, where care providers for major decisions, the hospitals and the doctors would look at next of kin in a particular pecking order for authorization for treatment. So the pecking order is pretty much common sense. Typically it's your spouse, and then it's your adult children, and then it's your parents, and then it's your siblings. And I can tell you from talking to many clients that that pecking order doesn't work for them, one iota. So those clients definitely need to have an actual representation agreement made up so that they get to choose who their chosen decision maker is, and that's not left to operation of law. So I think we are nearing the end of, yes, we are. We've neared the end of our content of our presentation, so we can take some questions. This last slide is a summary of the work that Fulton does in the estate realm. So we have, I believe, the only dedicated estate department in the region, with 2 estate planning probate lawyers like myself and 2 estate litigators like Tyson. And we have a full complement of staff, 6 full-time legal staff who are working just in estates. So we are we're well-versed and we're happy to help. So that brings us, Shayden, to the question portion, and I'm at your disposal.
Yeah, thanks again, Leah and Tyson, for taking the time to go through your slides and explain all of that. That was tons of information and great information. I've learned a ton. So jumping into some questions here, we've got lots to go through. The first one, is it a good idea to have your kids as power of attorneys and executors, or is it better to consider someone else?
It's very common to have your children as power of attorney. You know, if they have your best interests at heart, and they have the capabilities to do the job, it's very symbiotic, right? It can mean that they're rolling into the stage of caretaker of your estate while you're living. They look out for your best interests and caretake your estate, and then when you pass away, they sort of slide right naturally into the executor role. And there's not much of a handing over of the baton. It's the same person all the way through. It can be fine. It works really nicely. I mean, if it sometimes is problematic where there's other beneficiaries who don't trust that person, or where that person is not trustworthy, or where they're just for any other reason not a good person to choose and to appoint. But there's certainly no hard and fast rule about not doing it.
Great, thanks. And this kind of ties in with that. Can the executor that you choose be the heir or beneficiary of the will?
Yep.
I think you
sure
did touch
can.
on that before.
Yep.
Perfect. How often would you recommend a will be reassessed or updated to ensure that it's still appropriate and applicable?
I think the common rule of thumb is 5 years, pull it out every 5 years, but more appropriately, we just say whenever there's a big life event, like somebody who in your world, your next of kin gets really sick or passes away, pull out your will and think about how that could implicate your planning.
Yeah, along the same lines, one for me, and I've seen a few it's wills variation cases in particular that are sort of driven by this, is if you start a new relationship, and in particular if that relationship sort of develops maybe more than you initially expected, then you really got to look at your will again, because what you've provided, you know, might have been fair in the first few months you were dating the person. Now they've been living with you for 7 years. Maybe you're sick and they're a caregiver, or vice versa. That can really change the apple cart in terms of what's fair, and it can eventually, you know, lead that person to make a wills variation challenge if you've left your will in place from the first months of your relationship and haven't updated it. So that's a really good time to update it if you think about those kind of things.
Great, thank you. This question's from Brenda. Could you expand on the tax implications for a U.S. executor of a BC estate? Touched on that right at the beginning.
Yeah, the problem is that the estate is considered to be a trust under law, and trusts are taxed depending on the residency of the trustee. So the estate is a trust and the executor is a trustee, and if the executor lives in the USA, then the estate can be taxed in the US tax regime. So if your only option is somebody who resides in the USA, then you're going to want to get some cross-border tax advice to determine, is this really going to be worthwhile, or is this creating a whole bunch of nasty tax problems?
Thank you. So with expensive real estate, like in the Okanagan, I'm sure everybody's seen that, what might be the best alternative to protect any gift to children to buy homes from being lost due to the children's marriages breaking down?
This is a great question, and it's becoming more top of mind, especially as real estate prices rise. So a couple things. Children should be encouraged to make marriage agreements between them and their spouses, right? So these can be even in early days of a relationship where they are not truly married under the eyes of the law, but they're living together. And they might reach the point of being a 2-year common law relationship, at which point they would have obligations to each other if their relationship ended. And in that situation, we've seen parents become really influential in encouraging the child and the child-in-law to actually get a cohabitation
agreement. I had a client build one of those recently.
Yeah. And then another tool which works pretty nicely is if the parent is going to lend a lump sum of money to the child, or is thinking about gifting money to the child, is to characterize it as a loan repayable by the child and the child's spouse on demand by the parent. So that if that marriage breaks down, child's marriage breaks down, parent can call in the loan, and the now child-in-law is half liable on that loan. So the parent is going to be able to claw back at least half that money. So there's some tools available. Take some thinking though, and some consideration.
Yeah, I could definitely see how that would be complex, and you'd want the assistance of somebody like yourself.
Mm-hmm.
Okay, so this one is from Susan. She is I am the surviving spouse. The house and bank accounts are solely in my name. My 3 adult children are executors jointly. Walk me through what would be subject to probate and how it works. What are my options in order to avoid probate?
Great question. So Susan has no living spouse, and her children are her executors. And she has a house and bank accounts. So if Susan passed away today, Susan dies with an estate, right? The house and the bank accounts are in her estate, and they would all go to probate. And then the downside is the 1.4% probate fee, which is pretty minimal amount of fee when you consider it as compared to other taxes that we pay as Canadian citizens. Nevertheless, there is a probate fee payable. And so her options to avoid probate are, they're not that many, and they're not gonna, you cannot avoid probate in all circumstances, because to avoid probate, Susan needs to deplete her estate so that there's nothing passing through her estate, so that nothing goes through the will. So what is Susan gonna do? Maybe she's gonna gift that house to her children while she's alive, give it to them now, pre-gift. Maybe she's gonna give them money now. If she has money in an account like an RSP or a tax-free savings account that can have beneficiaries attached, she's gonna name a beneficiary so that that money's kept out of the estate. Maybe she's going to look at the joint ownership that Tyson talked at length about earlier. So maybe she would consider putting a child or children on the title of the house or on the bank accounts with her. But I'm not going to, I won't repeat all the cautions and all of the the negatives to that at this point, but there are a lot of them, so it has to be very carefully done. And in light of all of that, it may be that Susan cannot avoid probate because she has an estate. Having an estate is a good thing. It means you have assets in your name.
Yeah, I would just sort of take off on what Leah was saying there, that remember, it is only 1.4%. So if Susan's house and bank accounts add up to $1.5 million, that's still only $21,000. You could easily eat that up trying to do fancy trusts and estate planning techniques, and the risk you take on by something like a joint tenancy scenario are huge as well, and they're sort of intangible and unquantifiable. But to me, the dangers there are worth way more than $21,000. So it is a fee that people really try to get out of, but I think it's important to just keep it in proportionally in our minds that it's not as much as you might think, and it's not worth the maneuvering that some people do to try and avoid it.
Great, thanks for that addition. Appreciate it. The next question here is from Jonah. Are there any special considerations for when an older adult experiences dementia or is involuntarily admitted under the Mental Health Act?
So the first part of that question, we do get calls from time to time from children whose parent has just been developed or diagnosed with dementia. And so our first question is, okay, is everything in place for your parent now? So do they have their will set up? Do they have their power of attorney and their medical representation agreement? If they don't, can we still do it? Does your parent still have enough capacity to take those important steps? Because a dementia diagnosis does not shut the door necessarily. It's a legal test, and it has to be determined. Capacity to make a will, capacity to make a power of attorney is determined by the lawyer who is drawing up the document. That's a judgment call we make. And it's so the dementia diagnosis is not necessarily the end of the story. And involuntary committal under the Mental Health Act, this, that's going to be impacting the adults' freedom and mobility of their person and their ability to make decisions about their health care. They will still need somebody to manage their assets for them. So hopefully there's a power of attorney out there. If there's not, the next step could be a committeeship, which again is that court order declaration of incompetency and the appointment of an adult guardian for you.
Great, thank you. I have a couple of questions of my own. Now, generally, this audience is here to understand when and why we're doing these kinds of things. When is the best time to reach out to somebody like yourself or your team to start the planning process?
Good question. Even in very straightforward situations, we see people who are new homeowners. That's typically the stage in life when people start thinking about the importance of a will. They've just acquired a very pricey asset and they have something to protect now. So they're going to want to do a will and a power of attorney. But we see, honestly, we see people from all stages of life just starting out, and somebody who may be 75 with no will. Any time is a good time.
I guess the best time to plant a tree was 20 years ago. The second best is today. Perfect, thank you. This question from Ken: if a parent neglects to plan and get a power of attorney in place and then becomes mentally incapable of making those decisions, what can be done after the fact and how expensive would it be?
Yeah, so this is, unfortunately, you're kicked over into the realm of the committeeship order, which is the expensive. Like it can take 6 months or more to get a committeeship order over somebody, involving doctor cooperation, and sometimes that's the most difficult piece, is having 2 different physicians assess that patient and give an opinion about incompetency. And there's the attendant legal fees for the court application. So lengthy and expensive. if there's no power of attorney.
Thank you. Jaquetta just jumped in with the same question I was going to ask it. Does a will have to be created with a lawyer's help, or can I do it myself?
That's a great question. Especially in British Columbia, we have law that can elevate a scribble on a napkin to the importance of a will. So anything that purports to have testamentary intention or be of a testamentary nature, any document in writing, can be found to be a will. So no, you don't have to have a lawyer to draw up a will. There are myriad number of reasons why you recommend that you do, but it's not critical. I shouldn't say it's not critical, I should say it's not a requirement. And the requirements for making a valid will are that it's made by somebody who has capacity to make it, not under undue duress, so someone who's freely and willingly doing this, and who signs it in the presence of two witnesses. Those are the validity tests for making a valid will.
Perfect, thank you. So we're about 3 minutes left into the question period. If any of our participants or attendees do have any more questions, please fire them into the chat box. We'll happily ask them to Leah and Tyson here if they there's anything else. I've got one more. You had mentioned earlier that you know, potentially trusts are a way to go with regards to the beneficiaries of your estate. Now, circumstances may dictate like, okay, I have kids and they now have kids and they plan on having more, but they're not alive yet, or they, you know, any unborn grandchildren. What can happen there? How do you name that?
Yeah,
how does that work?
Good question. So it's entirely possible to name beneficiaries by just identifying a certain class of beneficiaries. If this happens, then my estate will be divided among those of my grandchildren who are living at my death. So you don't have to specify, and it will include unborn beneficiaries. They just have to meet the qualifications of being alive when you die. So that's a principle of drafting a good will, is planning for contingencies and things that you don't anticipate, but that you want to build in for. So it's absolutely doable.
Great, thank you. We may have time for one more question if anybody wants to get that in. But at this point, it doesn't look like we have any more. So I would just like to thank you, Leah, Tyson, Jaquetta. Thank you all very much for your time and joining us tonight. This has been a fantastic presentation. I know I personally have learned lots. We encourage you folks to attend the other events that are scheduled for the Embrace Aging Month. You can visit the Okanagan EmbraceAging.com for all of the events and the registration. We look forward to growing this event in the Okanagan and in the future and this year, and getting those participation numbers up. And if you do want to reach out to us, the contact information will be available on the website. Just so you folks are aware, you will be receiving a follow-up email from UBCO or from Jaquetta that has all of the information that went over tonight, the slide deck, as well as contact information there too. So thank you again, Leah Card, Tyson McNeil-Hay, Jaquetta Bernard, very much appreciated. If there's anything else that you folks want to go over, now's the time, but otherwise we're good to go.
Thank you for having us.
Thanks so much, Shayden and Jaquetta.